My name is Clara Ashworth. I'm 42. 9 months ago, I inherited a property from my mother. Not a clean inheritance. Not the kind where an attorney reads a will and hands you a deed, and you drive home understanding exactly what you now own. I inherited a property that came with an active civil lawsuit, a plaintiff I had never heard of, a legal liability my mother had been managing for 4 years without telling me, and a court date that was 11 weeks away when the estate attorney first called me and explained what I had actually received. The property was a duplex in a mid-sized city in the Pacific Northwest, a building my mother had purchased in 2003 and had managed as a rental since generating income she had used to supplement her retirement, and that she had described to me, when she mentioned it at all, simply as her investment property, the phrase carrying the easy confidence of someone who expects that the thing it describes is uncomplicated. It was not uncomplicated. It had not been uncomplicated for 4 years. My mother had been sued by a former tenant, a woman named Rose Calloway, who had filed a civil suit against her in 2020 alleging uninhabitable conditions, specifically a mold issue that had been identified in 2019, that my mother's property manager had been notified of in writing, that had not been remediated adequately or within the required time frame, and that had allegedly caused significant health impacts for Rose and her 2 young children during the 18 months they had continued living in the unit while the remediation remained incomplete. The lawsuit had been active for 4 years. My mother had been managing it with an attorney named Gerald Pace, paying his fees from the rental income the property generated, and had apparently made a decision, which I understand even as I find it difficult to fully accept, that telling me about the lawsuit was something she would do when it resolved rather than while it was ongoing, because she did not want to worry me, and because she believed, based on what Gerald was telling her, that the case would likely settle for an amount the property's insurance would substantially cover, and that the whole thing would end quietly before it ever became something I needed to know about. She died before it ended. It became something I needed to know about. Before I tell you about the court date and what happened when I finally met Gerald Pace and understood the full scope of what I had inherited, please take a moment to like and subscribe. Only if this story is landing somewhere real. Drop your location and local time in the comments. I read every single one. Now let me take you back to where this started. I need to tell you about my mother, Frances Ashworth, before I tell you about the lawsuit, because Frances is the reason the property existed and the reason the lawsuit was the specific shape it was. And understanding her particular way of managing things is essential to understanding why she made the choices she made, and why those choices, however understandable in the context of who she was, produce the situation she left me in. Frances was 69 years old when she died. She was, for the 42 years of my life, a woman of considerable practical competence and considerable emotional guardedness. The specific combination that produces people who are genuinely capable of managing complex situations and genuinely reluctant to share those situations with the people closest to them until the situations have resolved in a way that does not require the other person to experience any of the difficulty that managing them entailed. She was not secretive in a calculated or manipulative sense. She was private in the way of people who have spent their whole lives believing that difficulty should be handled and not displayed, that sharing a problem before you have solved it is an imposition rather than a connection, and that the people you love are best served by receiving the solution rather than being included in the process. This quality in her had served me well in certain respects throughout my childhood and had cost me in others. I had grown up with a parent who managed everything effectively, and who communicated primarily through the results of her management rather than through the process itself, which produced in me a specific combination of security and distance, the security of knowing things would be handled and the distance of not being allowed into the handling. By the time I was an adult, I had made a certain peace with this arrangement, understanding it as her particular way of loving rather than as a fundamental failure of intimacy. And our relationship in my adult years was warm and functional, and I had believed until the estate attorney called, genuinely transparent about the things that mattered. It was not, it turned out, genuinely transparent about the things that mattered. There was a lawsuit. She had been managing it for 4 years. I had not known. The property itself I had known about since Frances bought it in 2003, the year I was 33, and she was 60, and recently retired from a 26-year career as a hospital administrator. She had purchased it specifically as a retirement income supplement, with the practical, clear-eyed analysis of someone who understood, from a career spent managing healthcare budgets, that retirement income required active cultivation rather than passive hope. She had used a portion of her retirement savings for the down payment and had financed the remainder, and she had managed the property herself for the first several years before engaging a property management company, a firm called Pacific Property Solutions, when her own energy for the daily logistics of landlording began to feel, as she entered her mid-60s, like more than she wanted to sustain independently. Pacific Property Solutions was the operational center of the problem that eventually became the lawsuit. I want to tell you about this because it matters to understanding the legal situation I inherited, and because understanding it required me to reconstruct, from documents and from conversations with Gerald Pace, a sequence of events that my mother had experienced and managed but had not described to me. In 2019, a tenant in the duplex's lower unit, Rose Calloway, reported a moisture issue in the bathroom and one of the bedrooms. The report was made in writing to Pacific Property Solutions as the building's property manager, and Pacific Property Solutions responded by sending a contractor to assess the issue. The contractor identified mold growth behind the bathroom tiles and in the wall cavity adjacent to the shower, and recommended remediation that would require the bathroom to be taken out of service for approximately 2 weeks during the work. Pacific Property Solutions communicated this assessment to my mother and provided a remediation estimate. My mother approved the remediation. Pacific Property Solutions engaged a contractor. The contractor completed approximately 60% of the remediation and then, for reasons that the subsequent litigation was partly about, stopped, having been told by Pacific Property Solutions that there was a billing dispute that needed to be resolved before the work could continue. The billing dispute was real, a disagreement between Pacific Property Solutions and the contractor about the scope of the work relative to what had been quoted, the kind of dispute that is ordinary in the contracting world and that, under normal circumstances, would be resolved within a few weeks through negotiation or adjustment. Under the circumstances of this specific situation, where the partial remediation had left the mold issue incompletely addressed in a residential unit occupied by a woman with 2 young children, the billing dispute was not an ordinary contracting matter, but a health emergency that was being allowed to continue while 2 adults who should have been managing it argued about an invoice. The dispute took 4 months to resolve. During those 4 months, Rose Calloway continued living in the unit, having nowhere else to go, having a lease that entitled her to habitable conditions that were not being provided, and having communicated in writing multiple times to Pacific Property Solutions that the situation was affecting her children's health, that one of her children had developed respiratory symptoms that her pediatrician had connected in a written note that Rose had forwarded to Pacific Property Solutions to the indoor air quality issues the incomplete mold remediation had left unaddressed. My mother did not know about the written communications from Rose during this period. This is an important fact, and I want to establish it clearly because it matters to understanding my mother's culpability in the situation and to understanding why, when she eventually learned the full picture, her response was not defensiveness, but genuine distress. Pacific Property Solutions had been managing her communication with the tenants and had not been forwarding Rose's written communications to her. My mother had believed, based on what Pacific Property Solutions was telling her, that the remediation delay was a billing dispute being resolved and that the tenants had been informed and were managing. She had not been told about the health impacts being reported. She had not been told about the pediatrician's note. When the remediation was finally completed, 4 months after it had begun, and the unit was returned to a habitable state, Rose Calloway moved out. She retained an attorney. She filed a civil suit against Frances Ashworth as the property owner and against Pacific Property Solutions as the property manager, alleging uninhabitable conditions, failure to remediate in a timely manner, and negligence that had caused documented health harm to her minor children. My mother learned the full picture of what had happened in the period between the first contractor visit and Rose's departure when Gerald Pace began preparing her defense in 2020. She was, by Gerald's account, genuinely distressed and genuinely remorseful, not as a legal strategy, but as a human response to understanding that a tenant and her children had been living in conditions she had not known were as serious as they were, under the management of a company she had trusted, and that had failed to communicate the situation's actual severity. She terminated Pacific Property Solutions immediately. She instructed Gerald to pursue whatever settlement was reasonable, given the documented circumstances, and to make the process as non-adversarial as possible for Rose and her family. What she did not do was tell me any of this. She managed it, in the specific way she managed everything, as a problem to be handled rather than a situation to be shared. And she believed, I think sincerely, that handling it successfully meant resolving it, and then, eventually, describing the resolution rather than including me in the process. The process did not resolve on the timeline she had expected. Rose's attorney was thorough and, it turned out, was documenting a case that was more substantial than the initial settlement conversations had suggested. The insurance company was involved, as the property's liability insurer, and the insurance company had its own attorneys who were not primarily interested in the speed of resolution but in minimizing the payout, which was a set of interests that was not entirely aligned with my mother's actual preference, which was to resolve the situation fairly and quickly and to compensate Rose appropriately for what her family had experienced. The lawsuit was still active, moving toward a trial date that had been set for the following spring, when my mother died in January. She died of a cardiac event, sudden and without warning, at 69 years old, in the kitchen of her house on a Tuesday morning. She had an unresolved civil lawsuit. 11 weeks remained before the trial date, and Gerald Pace had her case file, and I did not know any of this existed. The estate attorney, a woman named Susan Hale, who had handled my mother's estate planning, called me 3 days after the funeral. She said, "Clara, there is a property in your mother's estate, and I need to tell you about a complication associated with it before you receive the deed." I said, "What kind of complication?" She said, "There is an active civil lawsuit naming your mother as a defendant. The property transfers to you as the estate's beneficiary, but the legal liability associated with the lawsuit transfers with it." I said, "I don't understand." She said, "When you inherit a property, you inherit it as it exists, including any legal obligations attached to it. The lawsuit names the property owner as the defendant. You are now the property owner." I want to tell you what I felt when Susan Hale said those words, because the specific quality of the feeling matters to understanding what came after. I did not feel betrayed by my mother in that moment. I felt, instead, the specific quality of being inside a situation that is much larger than it looked from the outside. The feeling of stepping through a door that appeared to open onto an ordinary room and finding that the room is the size of a building. The lawsuit, the plaintiff, the insurance company, the trial date 11 weeks away, the 4 years of legal activity I had not known about, all of it arriving at once in Susan Hale's careful attorney's voice on the phone 3 days after my mother's funeral. I called Gerald Pace that same day. He had known about my mother's death and had been waiting for the estate administration to identify the appropriate point of contact. He was, in the phone call and in the subsequent meeting we had in his office the following week, exactly the kind of attorney I would have wanted in this situation. Honest about the complexity of what I had inherited and about the options available to me. And specifically not the kind of attorney who tells you what you want to hear when what you need to hear is something more complicated. The meeting in Gerald's office was the first time I fully understood the scope of the lawsuit and the specific nature of what Rose Calloway and her children had experienced. Gerald had the case file, and he walked me through it chronologically. The mold report, the contractor assessment, the remediation beginning, the billing dispute, the 4 months during which the situation was incompletely resolved, the health impacts Rose had documented, the pediatrician's note about her child's respiratory symptoms, the termination of Pacific Property Solutions, and the settlement. Negotiations that had been ongoing for 3 years without arriving at a number that both sides could accept. I want to tell you what I thought about as Gerald walked me through the case file, because it was not primarily what I expected to think about. I had expected to think about the legal strategy, and the financial exposure, and the trial date 11 weeks away, and the insurance company's involvement, and the specific calculations of what a settlement might look like relative to what a trial might produce. I thought about all of those things, but they were not the first thing. The first thing I thought about was Rose Calloway's child, whose respiratory symptoms a pediatrician had connected to indoor air quality in an apartment that a billing dispute had left in a state of incomplete remediation for 4 months. That child had breathed compromised air for 4 months, while the adults responsible for the building argued about an invoice. That was the center of the story as I understood it. Not the legal mechanics, but the specific human cost of the specific failure. And I needed to understand it clearly before I could think clearly about anything else. I said to Gerald, "Tell me what Rose actually wants. Not what her attorney has been asking for. What Rose actually wants from this situation." Gerald said, "In my conversations with her attorney, what Rose has consistently indicated is that she wants acknowledgement. She wants someone to say directly that what happened to her family was wrong and that it should not have happened. The money matters, clearly, because her children had real health impacts and she has real medical bills and real documented losses from the period. But in every conversation, her attorney has indicated that the money is not the only thing. It may not even be the primary thing." I asked Gerald if I could meet with Rose directly, not through attorneys, not as an official settlement conversation, but as a human conversation between a woman who had been harmed by a building and the woman who now owned that building and wanted to understand what had happened. Gerald said this was unusual. I said I understood it was unusual. He made some calls and came back with an answer. Rose had agreed to meet. We met at a coffee shop, neutral ground, chosen by Rose's attorney who attended, but who, to his credit, allowed the conversation to be primarily between Rose and me rather than positioning himself as a barrier between us. Rose was 34, a small woman with the specific kind of composed watchfulness that comes from having spent 4 years engaged in a legal process that she had not chosen, and that had required her to repeatedly describe and document and prove the most difficult period of her recent life. She had her 2 children's medical records in a folder on the table in front of her, not because she needed to show them to me, but, I think, because she had gotten into the habit of bringing documentation to every meeting related to the lawsuit. I said, "Rose, I want to start by telling you that I did not know this lawsuit existed until 3 days after my mother died. I want you to know that not as an excuse, but as context." She nodded. I said, "I have read the case file. I understand what happened in your unit between the time the mold was first reported and the time the remediation was completed." I said, "What happened to your family in that period was wrong. The billing dispute that delayed the remediation was not your problem to manage, and you should not have had to manage it. Your children should not have been living in that unit during those 4 months. I am sorry that they did." Rose was quiet for a moment. Then she said, "Your mother's attorney has said things like that before in settlement letters." I said, "I know." I'm not saying it as a settlement letter. I'm saying it as a person who has read what happened and who wants you to know that I understand what it actually was. Not as a legal matter, but as a situation where your children were living in conditions that caused them harm, and that the people responsible for preventing that harm did not prevent it. She looked at me for a long moment. She said, "What do you want from this meeting?" I said, "I want to understand what you need, not what your attorney has been negotiating for. What you actually need to feel that this situation has been addressed fairly." She told me. It took about 30 minutes, and it was both more specific and less than I had expected. She needed the medical bills covered, completely, without negotiation. She needed compensation for the lost income from the period after she moved out, when she had stayed in temporary accommodations while looking for a new place to live and had been unable to work at her normal capacity due to her children's health issues. She needed documentation, a formal written acknowledgement from the property owner, that the conditions in her unit during that period had been uninhabitable, and that the failure to remediate them in a timely manner had been a breach of the lease and a violation of her rights as a tenant. And she wanted, specifically, for the documentation to be addressed to her children, so that if they ever needed it for medical or legal purposes in the future, they would have a clear written record of what had happened and who had acknowledged it. I said, "All of that is reasonable." She said, "Your mother's insurance company has been arguing about the amount." I said, "I understand that. The insurance company's interests and my interests are not the same thing." She said, "What are your interests?" I said, "My interests are to resolve this fairly and to make sure your children have what they need and to close a chapter that has been open for 4 years." She said, "Why?" "It would be easier for you to let the attorneys handle it and see what happens at trial." I said, "Because I read the pediatrician's note, and because I own the building, and because what happens in buildings I own is my responsibility, even when it happened before I owned them." I worked with Gerald and with the insurance company over the following 6 weeks to structure a settlement that reflected what Rose had described in that coffee shop meeting. The insurance company resisted parts of it, specifically the written acknowledgement Rose had requested, which their attorneys characterized as an admission of liability that could affect future claims. I told Gerald that I was prepared to provide the written acknowledgement regardless of the insurance company's position, because Rose had asked for it specifically, and because it was accurate, and because I believed that accurate acknowledgement of what had happened was not a legal risk I should be managing away, but something Rose and her children were owed. The insurance company eventually accepted the acknowledgement as part of the settlement after Gerald negotiated specific language that satisfied both their legal requirements and Rose's described needs. The settlement closed 5 weeks before the original trial date. The total amount, including medical bills, lost income compensation, and general damages, was covered substantially by the insurance policy, with a gap of approximately $38,000 that the estate covered from its own funds. I have since sold the duplex, the sale completing approximately 4 months after the settlement, and used the net proceeds to replenish the estate account and to make a contribution to a housing advocacy organization in Rose's city that works specifically on tenant rights in cases involving habitability issues. I want to tell you about a conversation I had with Rose's attorney, Michael Torres, approximately 2 weeks after the settlement closed, because I think it is the most honest summary of what this entire situation contained that I have encountered. Michael called to confirm that Rose had received the written acknowledgement and to say that his client had asked him to convey her thanks for the way the resolution had occurred. He said, "In the 14 years I have been doing this work, I have never had a property owner request a direct meeting with my client and open that meeting by saying that what happened was wrong. Usually, when the property owner changes, the new owner doubles down on the previous defense rather than reassessing it." He said, "Rose told me she feels like she got the thing she actually needed, which was for someone with authority over that building to understand what happened in it and to say so directly. That is not usually what happens. I want you to know that it made a difference. I want to talk to you directly now, wherever you are, whatever time it is. I inherited a lawsuit. I inherited a plaintiff I had never heard of, and a property I had not known was complicated, and a legal situation that had been building for 4 years inside my mother's carefully maintained privacy. My mother's intention in managing it privately was to protect me from worry and to deliver, when the time came, a resolution rather than a process. She ran out of time before she could deliver the resolution. What I learned from the 9 months between receiving Susan Hale's phone call and selling the duplex is something that I believe applies beyond the specific legal and financial circumstances of this story and into the broader question of how we handle the things we inherit from the people we love. You do not always get to choose what you inherit. The property comes as it is, with its history and its complications and its outstanding obligations. And the question is not whether you would have chosen to inherit what you received, but what you choose to do with it now that it is yours. Rose Calloway's children breathed compromised air in a building that is now mine. The lawsuit named me as the defendant the day I received the deed. Those two things together required a response, and the response I chose was the one I could live with, which was to understand what had happened as fully as possible and to acknowledge it clearly and to resolve it fairly. My mother managed things the way she managed things, privately and capably, and without sharing the difficulty until she had the resolution to offer instead. She did not live to offer the resolution. I had to find my own. I think she would have been proud of the one I found, not because it was easy, but because it was honest. And honesty was the thing she valued most, even when she struggled, occasionally, to extend it to the people she loved. That is today's story on the Family Ledger. Leave a comment wherever you are watching from. Tell me what time it is and whether you have ever inherited something complicated from someone who meant to protect you from its complexity and ran out of time. I read every single one. Subscribe for the next story every week. Check the description for another one I think you will connect with. Thank you for being here.